Welcome to this episode of Cash and Keys, Mastering the Art of Business and Estate Prosperity, hosted by estate and business planning attorney Larry Parman. Mr. Parman is the founder of Parman Easterday, a law firm that practices exclusively in the areas of estate planning, elder law, and business succession planning. He is the author of The Straight Shooter's Guide to Estate Planning and Economic Dominoes, a review of the economic cycle in the U.S. In these brief sessions, Mr. Parman will share information and insights on estate planning, elder law challenges, and how to successfully transition your business. Plus, there may be a few nuggets on other topics that will entertain and surprise you. Here's Larry Parman.
Hello, Larry Parman here again. I still have more on my mind, so here we go. This time I'm going to talk a little bit about what's called a Memorandum of Personal Property. Those of you who are clients know what this is about because we talk about this a lot. Here's the question. What do we do about distributing non-titled assets to beneficiaries? Non-titled assets would include household goods, furniture, fixtures, silver, china, jewelry, guns, coin collections, rings, etc. You can put those distributions, if you choose, into your document. My preferred way of handling that is through what's called that Memorandum of Personal Property. This is a method authorized in Oklahoma and many other states, whereby you can take that memorandum and you can identify the item you want to go to a specific person, write it out. Susie gets the 1-carat round diamond ring given to me by my grandmother. Billy gets my gun collection. Jimmy gets the coin collection. You're going to handwrite all that out and sign it. In your trust document, or at least in ours, there's a provision that stipulates that in making distributions of personal property, if our trustee finds a memorandum of personal property within, say, 60 or 90 days of the date of death, our trustee shall make distributions to those beneficiaries exactly as outlined on that memorandum. So it's a binding agreement. Now, here's what I like about that agreement. If one of those I'm kidding here a little bit, but you'll get the point. If one of those beneficiaries makes you mad, or more realistically, if there's something that indicates that they don't really care for that gift or want that item, you just tear that document up, rewrite it, and make, re-gift the item to somebody that you think would have more use for it, more interest in it, take better care of it, and so forth. So you can reflect your specific intentions of that specific item to a specific person in that Memorandum of Personal Property. It can be a very valuable, basically, letter of instruction, and it can give the trustee, your successor trustee, the guidelines to follow when making distributions of those personal, non-titled assets. Anyway, hope this gives you something to think about as you create or administer your own estate plan. And for those of you who have a trust, I recommend that if you do not have a Memorandum of Personal Property, or if you've not signed one, do so. You might want to check with your attorney to be sure that there's language in your trust document that provides for a distribution according to the terms of that memorandum. That would be important too. Anyway, enough on that today. Hope you guys have a stunning day. Larry Parman here, signing off. Take care.
If you would like to learn more about creating an estate plan for your family, protecting your assets if you have to go into a nursing home, or transitioning your business, call 405-843-6100 or send an email to info@parmanlaw.com. That's 405-843-6100 and info@parmanlaw.com. Thank you.